I call this meeting to order. Welcome back. Welcome to meeting number 38 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to order of reference of October 31st, the committee is continuing its study of Bill C-9, an act to amend the Judges Act. Today's meeting is taking place in hybrid format, pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to make a few comments for the benefits of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen to pick floor, English, or French, and for those in the room, you can select the same from your earpiece to the desired channel. A reminder that all comments should be addressed to the chair. For members in the room, if you wish to speak, please raise your hand, and if you're on Zoom, please use the raise hand function, and the clerk and I will do our best to place you on the speaking order. For your information, all tests have been successfully performed with our witnesses. So now I would like to welcome our first hour witnesses. Appearing today, we will have Indra Maharaj from the Canadian Bar Association Judicial Issues Subcommittee, and you'll be appearing by video conference. So you have 5 minutes, Ms. Indra Maharaj, and I will just let you know I use little cue cards. So when you've got 30 seconds left, just watch the cue card, and when you're out of time, use that and just wrap up so I don't have to interrupt your train of thought. So over to you for 5 minutes, Ms. Maharaj.
Thank you, and good afternoon, Mr. Chair and members of the Standing Committee on Justice and Human Rights. Thank you for the invitation to appear before you today. It is both an honor and a privilege to be able to present the Canadian Bar Association's position with respect to the issues that are raised by the proposed amendment, Bill C-9, to the Judges Act. My name is Indra Maharaj, and I am the chair of the Judicial Issues Committee. I would like to begin by recognizing that I am attending this meeting from the traditional territories of the Blackfoot Confederacy, the Siksika, Kainai, and Piikani, the Tsuut'ina, the Stoney Nakoda Nations, the Métis Nation Region 3, and all people who make their homes in the Treaty 7 region of Southern Alberta. The CBA represents lawyers, law students, academics, and judges across our entire country, where different First Nations have made their homes and stewarded the lands that form our unique and beautiful Canada. I will pause for a few seconds in silence so that each of us can acknowledge the treaty and/or traditional territory in our own location. Thank you. The Canadian Bar Association is a national association of 37,000 members, including judges, lawyers, academics, and students across Canada, with a mandate to seek improvements in the law and in the administration of justice. Specifically, with respect to Bill C-9, which was introduced on December 16th, 2021, the Canadian Bar Association has submitted commentary to this committee on February 17th, 2022, in support of the amendments that have been proposed. Among other things, the Judges Act establishes a discipline process for federally appointed judges in response to complaints filed with respect to their conduct. Recent government consultations underscored concerns regarding the length of time required to investigate these complaints and the consequent costs of investigation, including the potential cost of a member of the bench being unable to fulfill their duties while defending a complaint for misconduct. The CBA's recommendations are focused on ensuring that the objectives of protecting the independence of the judiciary and ensuring the public's confidence in the administration of justice are respected in this process. Bill C-9 amends the process through which the conduct of federally appointed judges is reviewed by the CJC in 3 significant ways. It creates a process for reviewing allegations not serious enough to warrant removal from office. It improves the process by which recommendations on removal are made to the minister. and it ensures that the determination of pensionable service for judges ultimately removed from office reflects their time of service and does not include the time of review, while ensuring that if the judge is exonerated, they do not lose that time that was spent defending the claim made against them. A little more detail. Firstly, the process for screening complaints that may not be serious enough to warrant removal from office is a positive development. It enhances the Canadian Judicial Council's capacity to respond quickly to allegations of misconduct and provides sanction options such as counseling, continuing education, and reprimands in these cases. This process saves the CJC time, ensures that judicial issues or resources are well managed, and minimizes the amount of time that a judge might potentially spend defending a frivolous complaint and not sitting on the bench. Secondly, improving the discipline process ensures that meritorious claims are moved forward and department resources are used efficiently. It also promotes procedural fairness and is designed to minimize delays and control costs. Thirdly, it is critical that judges, like any other litigant, are able to defend their conduct through a fair and transparent process and be satisfied that if they are ultimately exonerated, their pensionable service will be protected during the period of time dedicated to defending their case. However, it is equally important that time spent during the process does not contribute to pensionable service if the complaint results in removal of the judge from office. Judicial independence and judicial accountability are both essential to ensuring the integrity of our judicial system, the primacy of the fair administration of justice, and support of the rule of law. If our judiciary is to be respected and trusted, the public must be confident that judges are both independent of external influences and held accountable for their conduct on the bench through a fair and transparent process. Thank you. I'm happy to take any questions you may have.
Thank you, Ms. Maharaj. Now we'll go to our first round of questions, beginning with Mr. Moore for 6 minutes.
Well, thank you, Mr. Chair, and welcome to our committee, and we appreciate your perspective and your input from the Canadian Bar Association. One of the previous panels we've had, we understand, and all parties are supportive of this particular piece of legislation, recognizing the Canadian Judicial Council has been calling for a streamlined approach, and other individuals within the process, including complainants, have recognized that the current approach is dated and cumbersome, and there can be unnecessary delays. But when we look at the right of appeal of the decision, there's a mechanism in the legislation to appeal to the Supreme Court of Canada, which seems like a pretty lofty first option of appeal, and was raised by two of our witnesses, and a third concurred on questioning that it may be appropriate to have a right of appeal to the Federal Court of Appeal. And I'd like to get your thoughts on that for the perception of justice and the rules of fundamental justice. And I'm wondering, this idea that as a governing body, we would make a decision and your recourse is an appeal to the Supreme Court of Canada. Are we accepting that because it's judges that are on that panel, when if it was another group of peers, if it was doctors, if it was accountants, if it was some other group of peers that were passing judgment on one's conduct, would we accept that the recourse for that individual was just to appeal to the Supreme Court of Canada? Is that, could you make some comment on that, or do you have any thoughts on a right of appeal to the federal court being injected into the process?
Thank you very much for the question. the particular option that was offered by the Advocates Society, which was an appeal from the final review panel to the Federal Court of Appeal before an appeal might land with the Supreme Court of Canada, was not an option that we considered specifically. Although I have heard some of the other presentations, and they do note that the final appeal panel prior to the appeal potentially to the Supreme Court of Canada is comprised of senior members of the judiciary as well. And so in terms of the fairness or the administrative fairness of that particular process, the concept of where the appeals lie and how they flow through from the complaints process from the beginning through to the end appears to be considered. And with respect to the CBA's position, we have confidence in the consultation that has been done by the government in this regard. It's been extensive, and the result of that consultation is the bill that's before you, and that we do support that bill.
Thank you. And I think by and large, I would agree. This is legislation that was called for. But in light of this testimony that we've heard, it does raise the prospect if your recourse is an appeal to the Supreme Court, is that real external judicial oversight? Is that realistic? And I don't know if there's any analogous scenario in any other field. The consequences are severe: being removed from the bench, losing one's pension, and in your mind, should it matter that the people on that final panel that they are judges? Is that why we would be letting it slide in this case, that we're dealing with judges passing judgment over a peer versus some other group that has a peer discipline model?
Thank you for the question. I would hesitate to say that an appeal to the Supreme Court of Canada is allowing it to slide by if there's no appeal that precedes it that's external to the process. However, I would refer back to the fact that the judges themselves were consulted with respect to the process, and the result of that consultation did not generate an additional level of appeal. So all I can conclude from that is that it was not an issue of concern to the bench.
Okay. Thank you. And I only have 30 seconds left, but could you, do you have any quick comment on the current system where there is undue delays, and what do you see as the key to Bill C-9? Is there one overarching feature that you feel like if there was to be amendments, we definitely want to stick with some overarching feature?
Very briefly, 10 seconds.
10 seconds. The fact that the process has been streamlined in order to ensure that the process moves upward and forward rather than delayed laterally. That, I think, is the primary win, the primary goal in the amendment that's been produced.
Thank you. Thank you, Mr. Moore. And now we'll go to Ms. Briard for 6 minutes.
Merci beaucoup, Monsieur le Président. Bonjour, Maître.
Thank you, Mr. Chair. It's a pleasure to have you with us, Ms. Maharas. C-9 introduces a review process for allegations that could lead to the removal of a judge. And you have written in the letter sent to this committee that the screening process for these allegations was not was a step ahead. Is this a little step or a big step? That's my question. Do you feel that it's good for a review panel to be able to look at less serious complaints rather than simply sending the complaint over to a member of the CJC?
Thank you for the question. I do believe that this is a significant step forward because what it will allow the process to address or to focus on is the most serious of allegations that deserve an in-depth and thorough process. As one of the speakers in a previous panel has indicated, there are often complaints that are made against members of the bench out of frustration in the result rather than actual misconduct by a sitting judge. And it's important that those types of complaints are reviewed and assessed to ensure that there is no misconduct, but that they don't bog down the workings of the Canadian Judicial Council.
Est-ce que vous croyez que
Do you think that the sanctions that are listed under C9 for less serious complaints are justifiable or appropriate? For example, I'll let you speak to that further.
Thank you. The sanctions that are proposed for the less serious matters, such as counseling or continuing education or reprimand, are sanctions that are designed to be proportionate to the severity of the claim. And giving those options, making those options available, creates a certain flexibility in ensuring that the process responds fairly to the complaint and to the conduct of which a judge is accused.
en 2014,
In 2014, you presented a brief to the CJC, and you presented 16 recommendations in this brief. One was that you wanted to ensure that the complaint process for judges respect the objectives of fairness and independence of the judiciary and the confidence of the public in the administration of justice. Do you feel that Bill C9 meets these objectives?
Thank you. We do feel that Bill C9 meets the objectives set out in our recommendations. It provides a process that is responsive. It's responsive to the various types of complaints that could be made, and it's also responsive to the complainant's involvement as well as the judge's entitlement to defend themselves should they be accused of misconduct. What Bill C9 does is create a better balance than what we had before.
et on a parlé, vous en avez parlé.
And in your opening statement, you talked about the delays and costs involved due to the fact that there was a cost associated with the fact that a judge who was subject to review couldn't sit on the bench. Do you think that this legislation deals with this issue? That the bill deals with this issue?
Thank you. Yes, we believe that it does, because what the bill does is create a process that must move forward. Whereas some of the delays and some of the mischief, in fairness, that the bill is trying to correct is the gray zone that previously existed, whereby every decision of the CJC in a disciplinary matter could be subject to judicial review, which could be subject to appeal, which could be subject to further appeal. And so by streamlining the process, it becomes more fair and it responds to the concerns about the cost of the process because it must move forward. And so if a judge is not allowed to sit on the bench while there's a question about his conduct, then you can be assured as a member of the public that that will get addressed and that the judge is not utilizing the process in order to create a situation where they're not working, they're getting paid, and off they go and continue to proceed down the lateral routes.
Thank you. Thank you very much.
Thank you, Ms. Briard. We'll next go to Monsieur Fortin for 6 minutes.
Merci, monsieur.
Thank you. Thank you, Mr. Chairman. Thank you for being with us, Ms. Mirage, this afternoon. I'd like to go to the issue of sanctions. As my colleague said earlier, I think we are unanimous in the House. All parties will be supporting this bill. But one thing we need to look at is this whole issue of sanctions, the economic aspect. This is what people complain about the most, because if the judge is recognized as being, well, is found guilty due to a failure, the judge is then sanctioned, and people react by saying, hey, this cost us hundreds of thousands of dollars in legal fees, court fees, and the judge in the meantime will have his or her salary bona fide, and adjustments will be made if the judge is found guilty. But in your opinion, do you think that we shouldn't have adapted CN so in the event that a judge is found guilty, that he would be compelled to reimburse maybe the legal fees or pay for some of the court challenge expenses, which for issues that may seem dilatory?
Thank you very much for that question. The concept of having a party who is found to be unsuccessful in litigation compensate somebody for the legal costs of having engaged in the process is not one that's unknown in the litigation field. However, what is different about this particular scenario is that this is not litigation as between two people. This is a disciplinary process. And so the question about whether the fees that are compensated for, or the fees that are paid for on behalf of the judge who is defending their conduct, is one that is something that we haven't considered in detail at the CBA. It is, I believe, a recommendation that one of the other panelists has made, but at this point, I can't really comment further on it.
Thank you. I understand the distinction you're making between two civilians and where the judge has some authority in the case of a frivolous case. I understand that this is a different type of case. But the fact remains, this is an aspect that is talked about a great deal by the public, and it seems to me that it's significant enough, and I've asked various witnesses the same question, including the Minister of Justice, and so that's why I'd like to hear the opinion of the Canadian Bar Association, because the CBA plays an important role, obviously, in disciplining lawyers in various bar associations across Canada. I'm a bit surprised that you're saying that you haven't really given any thought to the matter or have an opinion on the issue. If that's the case, well, I'll leave it there. But Perhaps my question wasn't clear enough. And if you have an opinion, please express it. I'd like to hear what you have to say. Wouldn't it be useful or essential for a judge who convicted for misconduct that he have to assume at least part of the legal fees used to defend him?
Thank you, and perhaps let me see if I can be a bit more concise. The consultation that has occurred has not resulted in compensation of legal fees paid on behalf of a judge involved in a disciplinary process rising to the level of needing to be included in Bill C-9. That, to me, does not preclude an appeal panel making a decision that may be different. However, that being said, the CBA hasn't taken a position specifically with respect to this issue.
Merci. Je vais aborder.
Thank you. I'd like to talk about another topic. I think I have 30 seconds remaining, Mr. Chair. So very quickly, in your opinion, do you feel that the mediation of the CBA and the judge could be a step ahead, given a case of misconduct on the part of a judge?
Thank you. I'm not sure I understand the question. You asked about the mediatization of the CBA and the judge. Could you maybe ask?
Not the CBA, entre le Conseil.
Between the CJC and the judge concerned.
The particular case that seems to have triggered some of the amendments, the Giroir case. Is that correct?
Yes, but unfortunately we're out of time.
C'est un bon exemple, mais on est.
Yes, that's a good example, but our time's up.
Next, we'll go to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and thanks to Ms. Maharaj for being with us today representing Canadian Bar Association. I think you did very succinctly capture the challenge here that C9 is trying to meet, which is to balance independence of the judges with public confidence, but I would also add on, and the rights of those judges who are being disciplined. And so I want to return to this question of an effective appeal. We know the Supreme Court has set a very high bar for granting leave to hear cases, and that these cases must, in fact, in common language, be of national significance or national importance or constitutional importance before they'll actually hear a case. So I'm wondering in that case how often we could expect the Supreme Court would actually hear appeals from this process, given that very high bar they've set.
Thank you for the question. I think everybody in the room would hope never is the answer, because hopefully we don't have judicial misconduct that needs to be considered at a level of national importance. The reality is that the Supreme Court of Canada has limited time available to it, and it is selective about the cases that it must allocate that time to. And so that's why the leave process is there. And one of the other panelists earlier provided some information about some statistics around the number of cases that are where leave is sought and where leave is actually granted. So having a very high bar at the Supreme Court of Canada does support the fairness of the process, because what it does is it creates that ultimate authority where the Supreme Court of Canada is that ultimate judicial authority, where a case could end up, should it be justified, should it be of such substantial importance that the Supreme Court of Canada ought to contribute its wisdom to the case. Prior to that being granted, the levels of reviews contained in the process set out in Bill C-9 provide a robust and significant opportunity for all issues to be heard and adjudicated fairly in the position of the CBA.
And just to be clear, I meant no criticism of the Supreme Court for having that high bar for hearing cases. That's obviously necessary in terms of managing the work of the Supreme Court and sort of the integrity of the system. But I think once you say that, you're actually saying that the individual judge has no appeal from this internal process that is being run by the Canadian Judicial Council. So there might, in fact, be a miscarriage of justice there, which isn't of national significance or constitutional significance, but might still be a real miscarriage of justice. And I think that's why the Advocates Society was suggesting that an effective appeal would be to the Court of Appeal.
I think there's a question in between the lines there. And what I believe the answer is that you're seeking is whether the CBA aligns with the Advocates Society on their recommendation. And what I can tell you is that the CBA has confidence in the consultation, which included members of the bench, included the Canadian Judicial Council, and did not result in a need for an additional level of appeal.
Maybe is between the lines for all of us here is that when we talk about the review panel process, we say, well, it's judges. But with respect, it's judges fulfilling a different role than an appeal judge would fill. So in other words, the Canadian Judicial Council is bringing disciplinary proceedings, it's investigating them, and it's deciding. And so there's really no one outside that in-house process that will have an effective say over whether that's in fact fair if there isn't an effective appeal to something like the appeal court.
I'm not sure if you wanted me to respond to that specifically. Is there a question?
Yes, now, Mr. Garrison, if you can repeat the question.
So it did have a question mark at the end. Aren't we talking about two different roles of judges? So judges in their Canadian Judicial Council hat are playing a different role than a judge on an appeal court is playing, even though we call them both judges.
Thank you for the clarification. Yeah, I appreciate that there's a difference. However, when the judges and the members of that whole review panel are sitting in that capacity, remember there are also lawyers there, there are also lay members there. There is a broad and diverse opportunity for there to be consideration of the merits of the case. And the CBA supports the process that has been set out in Bill C-9 in part because of the depth of consultation of the affected parties that it has undergone. And while it's an interesting concept, the purpose of Bill C-9 is to remove levels of procedural duplication and to ensure that the core fundamentals of administrative fairness are met. And we believe that that is the case with Bill C-9.
Thank you, Mr. Garrison. Next, we'll go to Mr. Caputo for 5 minutes.
Thank you, Mr. Chair, and thank you, Ms. Maharaj, for being with us here today. I know it's not easy being the lone panelist here who's getting rapid-fire questions from a number of MPs, so I appreciate you being here. I'm going to pick up where Monsieur Fortin left off, and perhaps I could frame what I perceive to be his question a little bit differently. And that is this. I think in most law societies, particularly in British Columbia anyways, that if a person is sanctioned by the law society and the complaint is meritorious or founded, if you will, then there are often costs that are assigned against that lawyer. I'm not sure if that's what he was getting at, but from what I can see, that's not an option here. Can you comment on whether that might be something that's appropriate in the circumstances?
Thank you for the clarification. What I can comment on is the bill that's been provided and the fact that not every administrative step needs to be included in legislation. There are practices and there are procedures within any administrative tribunal where the issue that you've addressed may become something that is more logically lodged. It may sit better in an administrative process. The CBA has taken a position with respect to the bill presented, and as it does not include that particular concept, I can't make any further comment about it. However, not every step, every small step is included in legislation.
Okay, I thank you for that. I think I know where you're coming at it from. I mean, it's, so often we get into a pattern of comparison, right? For instance, a fine is frequently part of a lawyer's sanction as well, right? That's not present here from what I can see either. So I assume that if I was to ask you that question, we'd probably get the same answer as your previous answer. Yes. Very resoundingly, yes. Yes, okay.
Yes, you would, sir.
Thank you. Now, can I ask you a question about generally transparency? Transparency is a really big issue. It's obviously central to the rule of law. We have an open court principle generally, and in my view, transparency must be sacrosanct. Do you view Bill C9 as being appropriately transparent, not enough transparent, too transparent? Do you have any thoughts on that?
Thank you. That's an interesting question. I think the change to include lay members on the hearing panels adds a significant amount of transparency to the process. The fact that we will have the point of view of the public is something that I think is valuable in that regard. And certainly public hearings are public hearings, so that creates an amount of transparency as well. So I do believe that C9 has tried to seek that balance, has tried to establish the balance between those matters which are smaller and may not require that they be made public because they can be addressed through the screening process, versus those matters of more significance where we start to see a more formalized administrative process, a more formalized hearing process, and the involvement of the public in particular. I think the lay member is a valuable addition.
About 45 seconds here. So I will just ask you very briefly, you're somebody who's on the ground, you're likely involved in all sorts of committees. That's what people in your position often do. Is your sense that there was adequate consultations in respect of this bill? And you have 30 seconds.
Thank you. I think it is interesting to note that the bill was presented almost a couple of weeks short of a full year ago. And during that time, all of the major legal agencies, if I can put it that way, were consulted, as well as I'm sure numerous members of the public had opportunity to participate. So I believe that the consultation has been very robust with respect to this bill. Certainly with the CBA, we had opportunity to make our views known and to contribute, and we appreciate that very much. When I look at the breadth of consultation, I think that it is proportionate to the importance of this particular amendment.
Thank you, Mr. Caputo. Now to Mr. Naqvi for 5 minutes.
Thank you very much, Mr. Chair, and welcome, Ms. Maharaj. Thank you for going through all these questions. I really appreciate your thoughtfulness. I do want to pick up on your last comment around that. You're right, the bill was tabled some time ago and has had the opportunity for people to look at it and reflect on what's contained in the bill. In your perhaps personal opinion or on behalf of Canadian Bar Association, do you Do you feel, now that you have seen this bill in his detail, that it really addresses the concern around having a fair, open, transparent system around dealing with judicial issues relating to judicial conduct?
Thank you for the question. Yes, the CBA does support this bill, and we support it because we feel that it has gone through the mill and that it does create a balance between respecting the public's need to have confidence in the judiciary, as well as the judge in question's ability and entitlement to defend himself in a fair and transparent process. So yes, we agree.
Thank you. As we are deliberating on this particular bill, I'm of the view, and I've I presented that position before in this committee, that this is a process around judicial conduct. It is a bit unique than other administrative tribunal dispute resolution processes, especially given the light that we're dealing with judiciary, and there is a very important principle around maintaining and protecting the independence of our judiciary, and any system that is crafted must instill, enhance, and foster public's confidence in an independent judicial process. Do you think in CBA's assessment that Bill C-9 as presented accomplishes that important goal?
Thank you. The goal of judicial independence and the value of judicial independence cannot be diminished if we are going to have a strong and functioning judiciary. And so this bill does support the duality of the role of judge, insofar as a judge must serve and a judge commits to serve. So the exchange for that is that if there is a mistake made, because judges are human, if they make a mistake, that there's a fair process whereby that mistake of conduct can be examined. And given the screening process, given the new review process, the balance of ensuring that the judge feels they have an opportunity to address complaints made against them in a fair and transparent way, while still preserving the public's confidence that judges are being held accountable for misconduct in an appropriate manner, is a very delicate balance. In fairness, it's a delicate balance. And so the bill seeks to achieve that balance, and we believe successfully achieves that balance.
Thank you. So we have the issue, of course, of maintaining and protecting public's confidence in the integrity of a judicial system, and you spoke to that. But the balancing act around that is also to ensure procedural fairness and principles of natural justice as it relates to the respondent and the complainant or the applicant. Has the CBA done any analysis around whether this bill ensures procedural fairness and principles of natural justice? And are you comfortable that those key principles are also well considered or protected in this bill?
Through the various consultations with CBA members, sections, and different aspects of the CBA, it's a very complicated organization. We have had the opportunity to consider whether the principles of natural justice and fair process are being respected by the procedures that are set out in the bill. And we do believe that this is a fair bill. It balances the rights of all concerned parties, including the judge, including the complainant, including the public. And so we do believe that there has been fair consideration given, and we have had a fair opportunity to make our views known and compile our position together. There's 37,000 members, but compile the position on behalf of the Canadian Bar Association that we do support the bill.
Thank you, Mr. Nakvi. Next, we'll go to our third round with Monsieur Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Ms. Maharaj, I have only 2 minutes, as you've just heard. I'll be brief, but I'd like to go back to the whole issue of mediatization, which we weren't really able to deal with during the first round. There can always be discussions, but there's no process within the disciplinary process. Wouldn't it have been a good idea to have provided for meetings between the judge who's subject to the complaint and representatives of the CJC to try and negotiate a solution to the problem, particularly given the new provisions in C9, which, in my opinion, may add additional incentives to the judge to want to avoid a trial or a hearing before the CJC. In your opinion, do you not think it would have been good to have provided for such a process?
Thank you for the question, and I think I understand where I was confused before. I believe, Mr. Chair, that Mr. Fortin is asking a question about a mediation or alternative dispute resolution process that may precede a more formal process, whereas I was hearing mediatization and thinking media and public.
I think you're correct. I think in the interpretation there was just the sounding of the way the word was pronounced. Go ahead.
Okay, super. Thank you. Alternative dispute resolution is not it's not included as an obligation in Bill C9. As a preliminary step, there doesn't appear to be, in my mind, anything that would preclude a conversation towards an alternative dispute resolution or a mediation style of resolution, particularly with respect to the screening level of complaint. With respect to serious misconduct that could result in removal, I don't know that mediation would be something that would be valued by all of the parties involved. So I can't comment on that. I don't see in the bill that there is a requirement or an opportunity for mandatory mediation, but that doesn't preclude it from being a practice or being a procedure at a more administrative level.
Merci, Madame Maharaj.
Thank you.
And last, Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. There was another issue that was raised in our first session on this bill about the disclosure of the reasons for referral to a review committee and the legal reasoning that was used to reach a conclusion in the review panel. And in the current practice, and it seems it would be the same under C9, the complainants are only given a summary of reasons. They're not actually given the legal reasoning. And so the argument was made that you only get to see those once you file as a complainant an action for judicial review. And that both is costly, but also then results in the automatic release of those to the person. So the suggestion was made that we perhaps should amend C9 to ensure that those reasons were released at an earlier stage. That might in fact prevent people from deciding to ask for judicial review. But in order to see the reasons, now they actually have to ask for a judicial review. And I wonder if the Bar Association has any comment on that. I don't know what I call that kind of paradox that gets created there. If you want a review, you can't see the reasons until you ask for the review.
Thank you. That is the definition of a paradox. In terms of the CBA's position, the complainant does get a summary of the reasons. That's the way it's set up in the bill right now. Is there potential for there to be an earlier disclosure or a more detailed disclosure? Perhaps. But at this stage, it's not something that the CBA has identified as necessary, and it has not come out of the consultation and resulted in a place in this bill as being of significant importance, such that it ought to be legislated.
In your opinion, could the Canadian Judicial Council, in fact, require that earlier disclosure in their own internal standards for conducting the judicial reviews? In other words, might it be possible that could happen without putting that in the legislation?
That's a very interesting question, and unfortunately, I don't have an answer for you on that. I would have to be more familiar with the CJC's internal administrative processes to give you a fulsome answer.
Okay, thank you very much, Mr. Chair.
Thank you, Mr. Garrison. Thank you, Ms. Maharaj. I want to thank you for appearing as a witness. You've had a wholesome testimony and a lot of questions thrown at you, so job well done. We'll now suspend for a few minutes while we set up for the next panel, and we'll ask the next set of witnesses to come forward and those that are on Zoom to get their audio checked. Suspend. The second half of the committee, we now have, as an individual, Mr. Christopher John Budgell. I just want to say I'm pleased to welcome also Pamela Ford, who will help him assist him due to his hearing impairment. So, Madame Ford, please accept our warm welcome as well. Let us know if the meeting you need anything. Our clerk will be happy to help. And for those members, when you're asking questions, maybe just be loud and clear, as the hearing mic will not be helpful to Mr. Budgell, as he's told me. So just we'll give some extra time if we need to clarify anything in that regards. We also have Ms. Karine DeVos, Senior Legal Counsel for the National Council of Canadian Muslims. Welcome. And we have Naneka McGregor, Executive Director of the Women's Centre for Social Justice via video conference. So I'll begin by Mr. Budgell for 5 minutes, and then we'll go to the other two witnesses, and then there'll be rounds of questions. So over to you, Mr. Budgell, for 5 minutes.
Okay. Is this working? Yes. Okay. I'm just going to read my opening statement that I hope is short enough to leave me with a little additional time. From the record that I've been able to review so far, it appears that I'm the first witness, and maybe the only witness, that the committee hears from who is not a system insider. Though I note that you've heard from a couple of them, Professors Craig Scott and Richard Devlin, who are telling you things you haven't heard from Justice Minister Lametti and his Department of Justice staff. I am here solely because of my determination to be here. Where are the other voices speaking for the public? And I note that you haven't heard from any of the judges who are, or were before they retired, subject to the Judges Act. My immediate purpose in speaking to Bill C-9 is to argue that it should not be enacted, because it cannot be fixed. But I can go beyond that. You, the members of this committee, have a golden opportunity. The legal establishment's own dialogue, a good deal of which is accessible to the public, attests to the fact that Canada's justice system is in crisis, or perhaps that is justice systems in crises, because there are many components and many issues. If you proceed now to recommend to the House of Commons that it pass Bill C-9 and send it on to the Senate, you'll have missed a precious opportunity. The CJC perfectly illustrates the crisis or crises that the legal establishment is facing. The ship is crewed by the legal establishment, needs to be turned around to face the bow into the wind, and this is an opportunity to start turning that ship around. The publicly accessible record of the legal establishment's dialogue with itself shows that a, if not the, principal concern is the impact of these crises on lawyers, including judges themselves. Two sources I can note are the Lawyers Daily, an excellent publication that has served the legal profession for years, and the blog SLAW, slaw.ca. There have been many articles and posts about the stresses that lawyers and judges are facing, resulting in a good many of them suffering depression, and even what they concede is mental illness. There has been far less concern expressed about the impact of those systemic problems on litigants, especially those of us who are compelled to be self-represented. So on that note, I want to specifically mention two members of the legal establishment, Justice Yves-Marie Morissette of Quebec's Court of Appeal and Donald J. Nedolitsky, who, as an employee of the Alberta Superior Courts, has the curious title of Complex Litigant Management Counsel. I would characterize what they've been doing as building a thesis about what they like to call querulous litigants, the most extreme kind of what are conventionally called vexatious litigants. Justice Morissette did not coin the term querulous litigants. He attended an international conference held in Prato, Italy in 2006, and subsequently addressed a meeting of the Canadian Association of Counsel to Employers with a speech entitled querulous and vexatious litigants as a disorder of a modern legal system. The CACE posted a copy of that speech on their website. After I found it there and began commenting publicly about it, they removed that copy. There's a copy currently on the website of an entity called ProQuest. I've had some success accessing it there, but not consistently, as it appears to be a subscription website. I have attached a copy that I saved. Donald Nedolitsky has built on Justice Morissette's original thesis and is continuing to do so. They don't, of course, claim that all self-represented litigants are querulous or even vexatious, but those are the ones on which they have focused their attention. One reason this interests me is that my own history of litigation matches their description of the classic querulous litigant, so I can see what they are doing. I've just found this program of a meeting. I attached a link in here. Now, I've just found a program of a meeting held last May in which Mr. Nedolitsky contributed another version of his thesis, the responsibility of the tribunal to accommodate users with mental health issues. To access it, you can go to a link, expand the first item on the list, and then click on the link to Donald Nedolitsky's. Am I done? Okay, that's it.
Thank you, Mr. Budget. Hopefully you'll be able to get the rest out in your questions. And next we have Ms. Corinne DeVost from the Muslim National Council of Canadian Muslims.
Merci beaucoup, Monsieur le Président, and good
Thank you, Mr. Chair.
afternoon, members. Mon nom est Karine Deveau, and I'm
My name is Karen DeVoe.
National Council of Canadian Muslims. And we want to thank you for giving us an opportunity to be here today to provide our recommendations regarding Bill C-9, an act to amend the Judges Act. So we want to be clear at the outset that we are supportive of the goals of this legislation and of the legislation broadly. So the proposed reforms to the Judges Act aim to enhance the Canadian Judicial Council's capacity to effectively respond to all allegations of judicial misconduct against federally appointed judges, not just highly serious instances potentially warranting removal from office. So we are supportive of the passage of C-9, but we have two targeted amendments that we want to raise that we submit will improve this legislation. So we're here to make two specific recommendations. The first one pertains to lobbying, and the second amendment broadens the wording that is found at Section 90, subsection 3, and I will explain that later. First, we're recommending to amend Section 80 to add a subsection C to include lobbying directly or indirectly, and for the current subsections C and D to become subsections D and E. And we're recommending this amendment so that the motive or intention of a judge in their lobbying efforts are not left to interpretation, which very often leads to different results. And I can give you two examples. So for example, in a recent decision from the federal court involving Justice David Spiro from the tax court, the complaints alleged that Justice Spiro was actively engaged with a lobby group attempting to interfere with the appointment of a professor at the University of Toronto, whose views were at odds with those of the lobby group. The Honorable Madam Justice Kane of the federal court agreed with the review panel of the CGC, which determined that Justice Spiro engaged in improper conduct, but his conduct was not serious enough to impose ultimate penalty for judicial misconduct. And this matter did not go to a full hearing. Conversely, we have the case of Justice McLeod here in Ottawa, in which he was involved with a nonprofit organization and was advocating for social and legal reform for a certain group. In this case, the review panel determined that Justice McLeod engaged in impermissible advocacy and lobbying, and his matter proceeded to a full hearing on the complaints. So our amendment attempts to provide uniformity in the law and gives no room to interpretation. So whether you're actively lobbying or subtly, let's say, sharing emails that contain a position on a political issue, like the one in Justice Spiro's case, the complaint will automatically go to a hearing. And this will avoid different readings of the same law, which, as we have seen from the cases I've illustrated, resulted in different outcomes. As I mentioned earlier, we also seek to amend Section 90, subsection 3, by broadening the scope of impermissible misconduct that would restrict the screening officer from dismissing a complaint. As the provision stands, serious misconduct that may warrant a hearing but does not meet the threshold of discrimination or sexual harassment may be dismissed. So we appreciate, and like most lawyers, applaud the CGC decision in the past to remove former Justice Robin Kemp. However, our concern is that misconduct like his will be dismissed because it does not necessarily equate to sexual harassment or discrimination. And Justice Spiro's case is a good example that further outlines our concern. A screening officer may dismiss a legitimate complaint because it does not appear to be discriminatory on its face. That is, it's why it's necessary, at least in the initial screening stage, to apply a broader language that captures misconduct that is not directly discriminatory, but can still erode the public confidence in the judiciary and bring into question a judge's impartiality. Thank you.
Merci. Thank you, Ms. DeVost. Next, we'll have Ms. McGregor from the Women's Center for Social Justice for 5 minutes.
Thank you, Mr. Chair, Vice Chairs and committee members. I want to first acknowledge that I'm zooming in from my home on Indigenous land, the traditional territory of many First people of this land, including the Mississaugas of the Credits, the Anishinaabeg, Chippewa, the Haudenosaunee, and the Wendat peoples, and is home to many diverse First Nations, Inuit, and Métis. My work is done in solidarity with them, especially Indigenous women, girls, and Two-Spirit people who are the targets of ongoing systemic racism. And my submission today centers on our collective responsibility to ensure that they have equitable access to justice in this new process. My name is Nneka McGregor, and I want to also acknowledge my colleague Maya Roy, who co-authored this submission. I'm the co-founder and executive director of this organization. We're an NGO with pan-Canadian operations that works to eradicate violence against women, women-identified, Two-Spirit, and trans-identified people through personal and social advocacy. As an organization created by and for survivors, we use our shared experiences to help change public perceptions. Thank you for the opportunity to comment today. The focus of my submission will be on really Section 84 on diversity, focusing on identifying ways and opportunities for the bill to address systemic and individual biases, especially those based on race and gender, as a way of preventing further harm or impacting the integrity of the processes being proposed under this bill. I want to emphasize the critical importance of ongoing training on understanding and addressing gender-based violence, as well as training on uprooting anti-Black and anti-Indigenous racism and biases for all members of the judiciary, as well as ensuring that such trainings are mandatory requirements for anyone who will be serving in any capacity under this Act. In our work with survivors of gender-based violence, my organization frequently receives reports on how court systems re-traumatizes survivors of violence who are seeking justice. For example, in our 2019 research with survivors of gender and sexual violence across communities, we documented reports of bias based on gender and racial stereotypes and the impact on survivors' experiences of the criminal court process, including egregious statements made by judges in some of the cases. I want to share one example of a woman in Renfrew County who noted, and I quote, "Court process was almost more traumatizing than the actual incidents of violence. I ended up in hospital because of the court," end quote. It is also imperative that the judiciary and other parties selected to serve in any capacity under these proposed provisions have an evidence-based demographic understanding of how systemic oppression and human rights violations impact sentencing practices. The current demographic reality in Canada is that Black identified and Indigenous people are disproportionately over-incarcerated. For example, Statistics Canada has documented that 1 in 6 adult admissions into custody are from population groups designated as visible minorities. We know that these populations do not have greater propensity for criminal behavior than their white counterparts, but that the reason for the overrepresentation
Ms.
is, again,
McGregor, if you can just slow down a little bit, the interpreters are
Absolutely.
having a bit hard time keeping up with your speed, so just slow down slightly.
My
Thank you.
apologies. We know that these populations do not have a greater propensity for criminal behavior than their white counterparts, but the reasons for the overrepresentation is again due to systemic racism and pathologizing. I think it's important to note that I am not advocating for the ideological indoctrination of judges. Rather, our research has demonstrated the importance of identifying systemic bias in the legal system and the differential impact on rights holders to access justice in accordance with their charter rights. It is important that the committee incorporates the intersectional framework developed by the Black legal scholar Dr. Kimberly Crenshaw, who has written extensively on how court processes must be informed by the nuanced, evidence-based understanding of how historical, legal, and social inequities harm rights holders who experience both racism and sexism. Intersectionality has been judicially recognized across multiple Anglo common law jurisdictions. Moreover, scholars have documented Canadian legal frameworks have been embedded with preconceived biases and myths throughout, especially during trials and sentences. As noted by the legal scholar and historian Dr. Constance Backhouse, there is a, quote, professional culture of whiteness in the Canadian legal profession, resulting in judges who are, quote, not well equipped to address racism claims. The inaccurate and demeaning myths resulting in the systemic criminalization of Black, Indigenous, and or racialized Canadians and compromises our charter rights. I would invite the committee to consider the following recommendations. I think it's important that the anonymous complaints mechanism proposed remain because they're essential due to the power imbalances between the judiciary and lay people. I think the members of the Judiciary Review Panel and screening officers must undergo mandatory training to ensure sound technical and ensure competencies in areas such as gender-based and racial bias, intersectionality, Indigenous cultural sensitivity and humility, training that's developed by elders and knowledge keepers and delivered by Indigenous trainers. It's important that they have trauma-informed training and a complaint process that is based on transformative accountability and justice principles. And it's also important to ensure an independent, impartial, and representative review panel who have review panel members disclose any perceived or actual conflict of interest in relation to the complainant. And
Thank you.
to ensure...
Sorry, if you want to finish your second sentence, go ahead.
Yes, it's just to ensure diversity of representation of the review panel.
Thank you, Ms. McGregor.
Thank you.
Now we'll begin our first round of questions, beginning with Mr. Brock for 6 minutes.
Thank you, Chair, and thank you to all the witnesses who are here in person and online. Your participation is noted and very valuable to us, so I thank you for that. So I'd just like to inform all our panelists that this bill is going to pass. It is receiving consent and approval from everybody on this committee. And I bring that to your attention because I want to start off by questioning you, sir, Mr. Budgell. And I listened very carefully to your commentary, and you indicated that the justice system is in crisis, that the Bill C-9 can't be fixed and shouldn't be enacted. I did a little bit of research on your background, sir, and I understand that the National Post has proclaimed you a self-appointed citizen watchdog of the CJC. And I understand that in one of your blog posts, you've opined that Parliament has a unique opportunity to create an entity fully independent from both the judiciary and the executive branch to receive complaints and decide how to respond to them. In your opinion, this is the right solution. It always has been, because in your view, the fundamental problem with the CJC is that judges judging judges do not work. I take it, sir, you still stand by that position?
Any question?
The question is,
by that. Yeah.
Do I stand by that?
Yes.
Absolutely.
Okay.
And I could go further.
Well, I'm going to give you an opportunity because I know you ran out of time. But ultimately, from my perspective, I'd like to hear from you, knowing full well that this bill is going to pass and receive royal assent shortly. Can you offer any opinion, any suggestions that we can consider moving forward by way of possible amendments to make the bill a little stronger in your view or more appropriate?
Okay. Amendments, possible amendments?
Yes.
My concern, like anybody in my position, is what happens at the very beginning of the process. You've got you call it a screening process in the hands of the executive director and general whatever counsel, right? I don't know how many complaints are dismissed at that point. I know mine was, or actually the second one. I sent one in before that one, but it's over for the majority of people right there. And there are 2 screening stages right now. I expect there will be if C9 goes through, right? Those are
limited time, and I hate to interrupt you, but can you think of any possible recommendations, any amendments to strengthen this bill?
Are you asking me, can I recommend amendments?
Are you recommending ways that we can improve this bill?
Yes and no. I'm saying it can't be improved. But if you wanted to improve it, get rid of that. Okay. The solution I really want to see is that the screening is not done by the Canadian Judicial Council.
Okay. Thank you, sir. I'm going to move on to Ms. DeVoe. I did a little research on your background as well, and I followed along the case of Justice David Spiro in the media when this first was brought to the attention. Now, notwithstanding the CJC clearing the judge of not one but several complaints with respect to that decision, I understand that notwithstanding that decision, the Tax Court Chief Justice Rossiter has promised that that particular justice would not be assigned to anyone appearing with an Islamic background. That would be litigants, that would be lawyers. Is that still the case?
I think that decision was temporarily made. So I believe right now that he's back to his full duties. He can sit on those cases. But I'd like to verify that fact, and perhaps I can get back to your office with that answer.
Okay.
But my understanding was that it was temporary, but then, the judge was.
I understand that largely you are supportive of the legislation. You've recommended a couple of amendments. I didn't know if you ran out of time in terms of the narrative that you were describing during your opening statement. So with the last 20, 25 seconds, I'll allow you to complete that.
Yes, so I wanted to read out what the amendment would look like. So at section 90, subsection 3, it would read as follows. A screening officer shall not dismiss a complaint that alleges sexual misconduct or that alleges improper conduct relating to a prohibited ground within the meaning of the Canadian Human Rights Act. So we're removing discrimination and we're including improper conduct. We're broadening the wording of this provision.
Okay, thank you. I think, Chair, I got 10 seconds left. Over to you, Ms. McGregor. I think I got the impression as well you ran out of time, so 10 seconds or less. Can you complete your thoughts?
It was really merely to suggest that Bill C9 incorporates something more substantive around cultural training, training for everybody that's going to be part of the process, not just on race, but also on gender.
Thank you.
And I note that Section 84 talks about diversity, but the concern and the thrust of our argument is that just that mention about do everything we can to ensure that there is diversity. It doesn't go enough to uproot the systemic racism that is embedded in the judicial system.
Thank you, Mr. Brock. Now to Mr. Nakvi for 6 minutes.
Mr. Chair, I'm going to pretty much pick up where Mr. Brock was leading. So thank you, Mr. Brock. And I'll start with Ms. DeVoe first. So you were talking about the suggested language around Section 90. Can you sort of explain your rationale as to why you're suggesting that the scope be broadened as in terms of the language that you're proposing on behalf of NCCM?
That if a complaint comes in and it's not a direct discrimination, the screening officer may interpret this provision literally. And so if it's not a direct conduct of a sexual harassment or discrimination, that the complaint may get dismissed, even though it could be a legitimate complaint, because the conduct may appear to be discriminatory. And Justice Spiro, actually, that case is a perfect example. So on the face of it, when the complaint comes in, it may not appear to be discriminatory, but the conduct of the judge may lead one to believe that it is, discriminatory as you go along within the complaint process. So, and this is why we want to make sure that if we broaden the wording, that these complaints that could potentially be dismissed are not.
And you don't. So I'm looking at the wording of the provision, and your position is that the way it's drafted right now, it is not sufficiently broad enough to give that discretion to the screening officer?
No, not at all. We believe that if a screening officer looks at this and, for example, if I take the matter of Justice Spiro and the complaint comes in, sharing emails, interfering with a hiring process at a university may not in itself seem to be discriminatory, but the conduct of the judge is discriminatory.
So the conduct, the act that you're concerned with.
Exactly. So it's the conduct. And so we feel that if we leave the provision the way it is now, a screening officer will look at this and say, oh, well, he was not really, his conduct, like he was not discriminating against a certain individual, so we're going to dismiss the complaint.
And then in relation to Section 80, you're just suggesting that the word lobbying be added.
Directly or indirectly?
Directly or indirectly. We do run into the issue of then the definition of what is lobbying, and I'm assuming that your suggestion would be...
However minimalistic lobbying can be, it falls under that category, and it goes to a hearing process. Because now we're in a situation where the panel review qualifies what lobbying is. They look at what the judge does, and they do the exercise of qualifying it. And for example, in Justice Spiro, they determined that Justice Spiro was voicing a concern. He was not really actively lobbying, even though it was lobbying. And that's why we say that we want to add lobbying directly or indirectly. So however, I don't like to use the word minimalistic, but it seems it's considered lobbying. It goes to a hearing. Because now we have people or the review panel are looking at two cases differently, looking at the same law, but reading it differently. And so we want to bring, by adding the lobbying directly or indirectly, we're bringing uniformity. It's not left to interpretation.
So with the exception of these two suggestions, these two amendments that you're proposing, am I correct to assume that otherwise NCCM supports Bill C-9 and feels that it enhances the process of reviewing matters of judicial conduct?
It's a work in progress. That's why we're here. We like its goal. I think you had other witnesses this week that provided testimony on transparency and disclosure of documents. We do support that as well. But our focus for us today and for this bill was to focus on these two amendments that we proposed.
Thank you. Ms. McGregor, I will go to you now. And I'll come to your proposal around Section 84, I believe. Yes, Section 84 you're speaking to. But with the exception of that particular concern or enhancement in language that you want to see, I take it that you and your organization is supportive of Bill C-9 and the way it lays out the mechanism for judicial conduct?
In principle, we are, yes.
Sorry, you may have to repeat again.
I'm sorry, I said in principle, we are, yes.
Okay, great, thank you. So in terms of Section 84 that deals with diversity, your position is that language is a good start, and there needs more to it, which is around, as I understand, you were speaking more of training of members of the review panels to make sure that they have training around unconscious bias and systemic racism, those type of important matters.
Very briefly, Ms. McGregor.
That's correct, because I think part of the challenge is who has access and opportunity to actually begin the process of complaints, right, of bringing a complaint, and understanding that Black and Indigenous women who are systematically discriminated against are one of the last people to feel that they have a voice and that they have an opportunity to speak, to complain about a judge because of the inherent biases and racism and discrimination that they face at that intersection of gender and race. And so for us, it's beyond training, it's more about a culture shift.
Thank you. Thank you, Mr. Naqvi. Next, we'll go to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'd like to ask Ms. DeVoe a question. You talked about lobbying early. I'm not certain I follow you. I understand you said that we have to distinguish between indirect and direct lobbying. But what lobbying are you referring to exactly? What do you fear to see a judge doing in terms of lobbying that could, in fact, harm us? What I mean is that a judge could be engaged in lobbying. Let's use a concrete example. Judge Spiro, because of his previous affiliation with the University of Toronto and the lobby group, he was chair of that group. We communicated with him. He was asked to do an appeal on behalf of the University of Toronto to influence the results with respect to a candidate who was supposed to have a position at the university. Do you know? Are you familiar with this? I'll back up a bit. So he intervened in the appointment process at the University of Toronto. Exactly. And what happened is, even though the candidate had all of the credentials for the job, once the judge called the university, everything fell apart for the candidate. So it's a form of lobbying. What happened is the vice chair, when the complaint was filed, the vice chair said that he feared a bias, and that's why he determined that the file should be pursued further. So it was indirect lobbying. It wasn't a case of where the person, as was the case with Judge McLeod, who met with MPs and on behalf of a charitable organization. That's why we're saying.
Lobbying. Je m'excuse l'anglais-français.
I apologize for switching back and forth between French and English. So regardless of what type of lobbying is involved, we don't want to have a different interpretation of what constitutes lobbying. Did I answer your question? Yes. Now, are there any other examples that come to mind when you talk about lobbying? I understand that the Judge Spiro did not when what he did was improper. But are there other cases of lobbying that lead you to propose or suggest this amendment? If a judge uses his position to influence anything whatsoever, with Judge Spiro, it was with politicians, and it's a type of lobbying. Okay. Thank you, Ms. DeVos. I'd like to know, and this is a question for you, and maybe we could hear from Ms. McGregor after. In your opinion, do you think the judge appointment process, do you think it should be reviewed based on the various criteria that we're talking about today? Do you think it would be useful that we amend the way we appoint judges? Thank you for your question. That's a really good question. And I don't have an answer for you right now, but I'd be prepared to send you further information to your office, or my colleague could perhaps answer, but I can't really answer that. Thank you, Ms. DeVos. Ms. McGregor, could you talked about, you said that anonymous complaints should be possible. Aren't you afraid that this will create situations where it'll be difficult for a judge or the CJC to determine whether the complaint is serious or not if it's anonymous? How would you see such a process unfolding?
Can I just, thank you for that question, but can I answer the first one that you asked to my colleague on the panel around the process for appointing judges?
Oui, allez-y.
Oui.
Please go ahead.
So, yes, I think that the process that's currently in place for appointing judges is flawed, because if you actually examine the number of judges and sort of break it down by demography, racial demography, you'll find that the system is heavily whitewashed. And how in a country that has diversity, such as Canada, to have this overrepresentation of typically white, typically male judges should tell you something, that there is something wrong in the system because other identities, other individuals are not being represented. So to answer the question, do I think there could be something changed? Absolutely, there could be a lot changed. And like my colleague, I'm happy to send you some recommendations on ways to do that.
Thank you,
Merci, Madame McGregor.
Thank you, Monsieur Fortin. Next to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and thank you to all the witnesses for being with us today. It's certainly expanded the range of the topics before us, and I think that's important. I want to go first to Ms. DeVos we've talked a lot about the lobbying recommendation, but the other recommendation for Section 90, subsection 3, I guess my question is, what's brought this section to your attention? What experience here are you responding to? Is it high-profile cases which were dismissed, or is it the volume of cases that were discussed at screening, or is it both?
No, it's thank you for your question. It's just that we just want to make sure that there's uniformity, okay? And we want to make sure that because this provision, the way it's read, is very not limited, but it deals with two specific things, right? Sexual harassment and discrimination. And we feel that if a screening officer receives a complaint that is not, and again, I sound like I'm repeating myself, but doesn't fall within those two parameters, then it will be dismissed. So by broadening the provision or the definition, then complaints that are legitimate, that may not on its face or at the beginning of the process seem to be legitimate, will not get thrown out or dismissed and will go through the process. So that's the reason why we were looking at this provision, and we feel that it would be a proper amendment to make to this bill.
I think I see what you're getting. I'm trying to do a little parallel here. As a gay man, I've quite often been told I haven't been discriminated against by someone who didn't have an understanding of what actually happened. So I'm using that as a kind of parallel. I think that's what you're getting at. Sometimes the person doesn't have lived experience, or they don't have a detailed understanding of how discrimination functions. Something on its face might not appear as discriminatory. Is that what we're talking about here?
It's one explanation given to it. Yes, definitely.
And are there others, or is that pretty close to the heart of it?
Yeah, it's pretty close to the heart of it. But like I said, we don't want somebody to read the provision literally, and like you say, may not be understanding of what a discriminatory conduct may be, and say, well, this was not discrimination, and this, it goes ahead and dismiss the complaint.
My understanding is we don't actually have good figures on dismissals of complaints and reasons for dismissals. Would you agree we don't actually have good data on that?
Well, we just heard from the witness here saying that his complaints were dismissed in the beginning. I think I read yesterday, I was reading, and I saw that a lot of complaints are getting dismissed. That was my understanding. A lot of complaints are getting dismissed at the screening stage.
Right. So I want to turn to Ms. McGregor on the same topic, the proposal from the National Council of Canadian Muslims on the Section 90, subsection 3, and get your reaction to that proposal to broaden the context of things which must be looked at.
I completely agree.
And could you give us a little more about why you might agree with that?
No, I think her answers were quite explicit, and I completely agree. I have really nothing more to add. She said it very eloquently.
Do you think your proposal for mandatory training on systemic racism and gender-based bias would actually help in terms of this problem of screening officers perhaps not understanding and dismissing cases?
I think that's a really foundational part of the work. The challenge is to have the types of training that's actually going to result in attitudinal shifts, as opposed to training that is delivered as, to check off a box. The challenge for us is really, how do we ensure that everybody that is part of this process has abandoned their biases, abandoned their prejudices, and is looking at every complainant and every judge as well as, we're here to protect individuals' rights, we're here to support access to justice, and we're doing it from a place of nuance and understanding. And you cannot do that unless you have grounding in human rights, and you have an understanding of anti-Black racism, anti-Indigenous racism, and gender-based violence.
We've certainly seen I guess I'll use reluctance, a reluctance of sitting members of the judiciary to accept the idea of mandatory training. And so, for instance, the bill that we did pass that requires training is only for new appointees. to the bench. What's your reaction to that objection to mandatory training as an interference with independence of judges?
If I'm to be very honest, I think it's ridiculous. We actually did a lot of work with the National Judicial Institute to develop training for candidate judges around this issue of gender-based violence and racism. And it was a lot of negotiations back and forth between us and Justice Adele Kent, who was a former executive director there, before we finally managed to land on I think it was a 2-hour training that was recorded. And that same complaint around interference was raised numerous times. There is a difference between interference and getting yourself educated about the reality of the society in which you live. There is a difference between interference and having you understand that you have people have biases and blinkers that is influencing the way that they are meting out justice in the courtroom. And trying to get people to get to that level of understanding is not about interference, it's about uplifting and education.
Thank you, Ms. McGregor.
Thank you very much for that response. Thank you, Mr. Chair.
Thank you, Mr. Garrison. Now we'll go to Mr. Caputo for 5 minutes.
Thank you, Mr. Chair, and I'm going to pick up on where Mr. Garrison left off here on mandatory training, because I think it's interesting. One of the things that I'm quite passionate about is this issue of secondary victimization that I believe was you in your opening statement outlined. I can't tell you how many victims I've seen who have described the court process as itself worse than the initial offense. Often, not always the case, but it's never easy, and it's often unduly burdensome. And that often comes down to things like adjournments, applications under Section 276 of the Criminal Code maybe being brought late, things like that. So I find it very interesting because you, especially in this really, I think, applies more to federal appointments than provincial appointments. I mean, provincial appointments, provincial court judges typically deal with small claims, family court, criminal court. So they're going to come from typically criminal family. But for a federal appointment, somebody could be a construction litigator, for instance. That could be where they kind of made their mark in their legal career. And then 2 months later, they're doing a jury trial for a complicated sexual assault, right? So I'm very interested about secondary victimization, and I want to pick up on this issue of education and ongoing education. Would you agree that we are just now starting to really understand how victims react, and this is a fluid research area that we're, I guess, making strides in as we speak?
I completely agree. We are actually doing work on the impact of brain injuries, traumatic brain injuries sustained as a result of intimate partner violence, and how those brain injuries actually impact and impede the witnesses' abilities to testify, and how when they are testifying, because of the brain injury, their attitudes and their demeanor is misunderstood as being belligerent, whereas in fact it's a result of the brain injury that they sustained. We're also doing work around the neurobiology of trauma that is explaining how trauma also impacts the witness to the crime. And so the idea of developing a very robust, comprehensive analysis that helps everybody in the process better understand the experiences of victims of violence in order for them to better provide services, right, and better provide justice for them, I think is essential. And the biggest challenge is to have these types of trainings as checkboxes and 1 hour to undo a lifetime of discrimination that has been ingrained in you. It's not going to work. So for us, it's about how do we instill a culture shift by providing comprehensive, ongoing training around these issues.
No, I certainly understand that, especially when the literature is changing and developing. It seems to me that it would be incumbent not only on the public to want it, but to the judges themselves. I don't know any judges who say, yeah, I'm going to set out to not make the best decision I can. Part of the best decision you can make, especially, well, in any context, is understanding the witness who's before you. And understanding the witnesses before you, as you mentioned, is that trauma-informed practice. So I thank you for that contribution. Now, you didn't get to finish your comment on anonymous complaints, and I was going to ask a question about it. I find this interesting because I believe that 2 members of the reviewing panel would have to approve an anonymous complaint. You didn't get to answer your question about it. The floor is yours for whatever time I have left, if you'd like to answer that question.
Absolutely. Thank you so much for the opportunity. I think the issue, and it goes back again to my point around Black women, Indigenous women, trans women who have traditionally been silenced and traditionally not believed by the judiciary and believed by the criminal legal system. The fear that is ingrained in us to actually then step up and file a complaint against a judge who has tremendous power. Whether anybody believes it or not, the judge has tremendous power when in relation to a complainant who, again, when you look at the intersection of the race and the gender. So having an opportunity for this anonymous complaint to be filed, I think is a really compassionate and a really progressive way to engage individuals who are traditionally marginalized, what my colleague Dr. Topwai Farrakhan calls people on the margins of the margins, who don't have an opportunity, don't have access, don't have money, don't have resources.
Thank you.
This is an opportunity for them to come forward.
Thank you, Ms. McGregor. Thank you, Mr. Caputo. Now to Ms. Dillon for 5 minutes.
Thank you, Mr. Chair, and thanks to our witnesses for being here today. I'm going to start with Mrs. McGregor. You spoke about a 2019 study in your opening statement. Could you please tell us a little bit more about what kinds of discrimination is seen? Can you give us some examples, please? Thank you.
Thank you very much for the question. What we did was there were 2 parts of Ethics Approved. One was a series of interviews with women in rural and urban communities who had been raped and who reported and therefore went through the system, and a series of one-on-one interviews with women who had been, focus groups with women who had been raped and who didn't report, and try to understand why, what was the barriers that women were facing. And one of the things that became quickly evident in the focus group with women who were raped and didn't report was that was the only site where we found Black women in the community, because Black women who were raped were reluctant and fearful of going and reporting to the police because they see police as an unsafe place. Women who were raped and reported, whether in rural or urban communities, were generally white women, right? So understanding the point I was making about intersectionality and Dr. Crenshaw's intersectionality as a framework will help people better understand what systemic racism is doing and how it is ensuring that Black women, as an example, Indigenous women, trans women, are not having access to justice, which then makes the whole system a mockery. If not everybody has access to justice, then nobody has access to justice.
Thank you for that. You also spoke about the over-incarceration of Indigenous and Black people. Do you believe that this is because of the racial biases you spoke of during your opening statement, and you just mentioned from the starting process until the very end, from when the file of the complaint is first made until being judged? Could you please tell us if this is another reason? Do you believe that there's over-incarceration of Black and Indigenous people because of these biases, because of the decision rendered on their case, on their file, when they're in front of a judge, by the judge?
Unequivocally. I mean, in my opening statement, I talked about the fact that it isn't because Black and Indigenous women, girls, Two-Spirit people have more propensity for criminality or criminal behavior. It is because of racism. I had a conversation recently with the CEO of the National Federation of Friendship Centers, who was saying that in federal prisons, up to anything as high as 90-something% of federally incarcerated women are Indigenous. which is a ludicrous figure when you consider the population, the percentage of the population that Indigenous women have in Canada is about 2.3, 2.5%. And nobody can tell me that that is anything other than racism that has resulted in such a small population being so grossly overrepresented. And the same goes for Black women and trans women. So for me, it is a clear indication of how the system is set up to disadvantage and discriminate against certain populations and do it with such impunity. And we're hoping that with this bill, with our proposal that more attention be paid to the process of hiring and ensuring that individuals who are administering the process are individuals who are educated, understanding, empathetic, and really, really grounded in intersectional understanding of race and gender.
Thank you for that. And I guess it would be on the other end as well when there are victims who come forward and, as you said, they don't feel like they're being listened to. Again, this comes to those biases. You spoke about also not being able to understand the different cultural nuance, racial nuances. Can you speak to us a little bit about that, please? As well, because I'm running out of time, about tacit discrimination. How do we address tacit discrimination? Sometimes there's eye rolling, sometimes there's words like "you people." So please, thank you.
Yeah, thank you so much. That's not tacit, that's explicit in my opinion. So the issue of implicit and explicit biases everybody has it. But when you're in a position of power and you're using that as the basis on which to judge and discriminate against certain members of the population, that is something that we're trying to uproot. And there are many people doing this work, and I just want to spend a few minutes and talk about my brilliant colleague, Dr. Rachel Zellers, who's
Unfortunately,
done a lot of
Ms.
training
McGregor, you don't
that.
have a few minutes. You're over time.
Thank you.
I want to thank all the witnesses for this study and thank the time that they've given. It's very valuable testimony. That concludes the testimony part of this meeting. I just have a few matters I just want to mention. The witnesses are free to leave if they want, but they can sit around if they'd like to see. So members, we will be proceeding to study the draft report on the government's obligation to the victims of crime. You should receive a first draft, confidential draft tomorrow in order to prepare for Monday's meeting. So hopefully that'll give us enough time. That's what the analysts have told me. We'll have to adopt a budget to reimburse our witnesses who appeared on Bill C9 and to adopt a revised budget for the trip in March 2023. And I also want to remind that you have a deadline to submit amendments to Bill C9 is on Monday, November 28 at 6 p.m. So any amendments to Bill C9. Finally, yesterday we received Bill C-291, an act to amend the criminal code and make the consequential amendments to other acts, child sexual abuse material. We will have to find time to proceed to this study. This is, I think, Mr. Mel Arnold of Northern Okanagan Shuswap, who's presented this bill in its past. So we have to report the bill at the latest in 60 sitting days days after the date of date of order of reference, and that is April 26, 2023. So we have some time for that. And yes, Mr. Garrison.
Mr. Chair, can I just ask that we, for the committee business section, have a proposed revised schedule to accommodate the various things that have been dropped on us, and also just to confirm if we're having the minister for estimates and when. I'm not asking today, but if we can have a revised schedule to look at on Monday, that would be helpful.
Sure. Mr. Clerk can probably answer that right now. He said, go ahead.
Certainly, Mr. Garrison, as the meeting was going on, I just updated the calendar, so I can circulate it pretty soon, maybe even after the meeting.
Thank you.
Mr. Nansangari, did you have something, or you're good? Okay. We'll adjourn.
Thank you.